Our next presenter is Casey Forbes, and Casey currently is a staff attorney in our West Virginia Supreme Court Clerk's office, and prior to that he was a clerk for the West Virginia Supreme Court. Before joining the West Virginia Supreme Court, he was a staff attorney for the legislature. He was an attorney in private practice that was occasionally appointed as a guardian ad litem, and he was assistant attorney general, where he spent the majority of his time writing briefs and arguing cases before the West Virginia Supreme Court. And he's going to talk to us about appeals and your responsibility as guardians when you're coming before the West Virginia Supreme Court.
Thank you, Lisa, and the other organizers. So thank them for having me. Thank you all for being here despite the weather conditions. I'd also like to say I did spend some time doing guardian ad litem work, so I feel your pain, and it's thankless work at times, but it's extremely important. I have 2 kids myself now, and didn't when I was doing that work, and it's just seeing some of the issues that parents struggle with, and I struggle with, with our kids. I can totally understand I understand a new level the importance of guardian ad litem work. I mean, kids are vulnerable, they need protectors, so thank you. Again, my name is Casey Forbes. I'm a staff attorney with the Clerk's office in the Supreme Court, and I've only been in the office for about 8 months, and this is the first time I've presented in that capacity. So what I thought I would do is just walk through some of the procedures, some of the highlights really of family court cases at the Supreme Court level. Obviously, not all of your cases end up there, and then you may not practice in the Supreme Court in that capacity. So, some of the things we'll talk about are how an appeal is docketed, how an appeal is perfected, the response, the reply, some of the practical steps and stages in an appeal, some other points and tips for motions practice in front of our court, oral argument, which obviously does not come up in every case, but does occasionally, so do some tips on that, and the types of consideration the court takes in cases, opinions and decisions, petitions for a hearing, and how a case ends. So, I don't know how long you've all been practicing. By the time I started practicing law, the new rules of health procedure had already been in place. They were actually just getting old. And in 2010, there was a major shift in our court. And under the revised rules, appeals are now by right. And it really affected docketing appeals and perfecting appeals. I get called probably about once a week from attorneys around the state in various cases where they haven't practiced in front of our court in 25 years, and they haven't experienced the new rules, and they get a lot of questions about that. So the new rules are on our website, and there are a lot of other resources on our website that are very useful. Virtually all the court rules are on our website. Forms, standard forms, forms for payment, guardians ad litem, appointed, the notice of appeal discussed is on our website. There's some valuable resources there.
Casey.
Pull the microphone up a little.
Pull the microphone up.
Thanks. So, the time frame for family court appeals. So as you probably know, a notice of appeal must be filed within 30 days of the entry of the final order. This says a final circuit court order. There are instances when a case comes directly from the family court to the Supreme Court. Those are rare. Once the notice of appeal is filed, it's proper, then a scheduling order will be entered. The appeal must be perfected within 4 days by rule and by statute. There's a response period, 45 days, and a reply period of 20. So, a reminder regarding filing deadlines. This happens quite a bit, and it does come up as an issue. The filing deadline is the date that it's due in our office, not the date it's stamped in the mail, not the date it's sent out. The date it's actually received in our office, the date it's stamped filed. So, with that, step one, the notice of appeal. So, a case is docketed with the filing of a proper notice of appeal, and we'll get into those. You must file an original and 5 copies, and you serve 1 copy on each party, a court reporter if transcripts are proper, and a circuit clerk. And what I thought I'd do, because there are cases where guardians ad litem are the petitioner and they do appeal in order. That's somewhat rare too. Generally, guardians ad litem are going to be respondents in these cases, but they can be petitioners. So I thought I'd walk through both aspects. So, a couple points in the notice of appeal. If you ever file a notice of appeal, they're generally pretty straightforward. They have information you have to list, and they have boxes you have to check. One thing that should be noted, and the petitioner has a responsibility to note this in the notice of appeal, is whether a case is confidential. A lot of practitioners in family court cases mark that the case is not confidential, and that is not generally true. So, portions of the record below are often, generally in family court cases, confidential. So, if a case has been determined to be confidential below, at the family court or circuit court level, which by statute they generally are, orders are not in most instances, but pleadings and other material is. If it's confidential below, then it's confidential in our court automatically. If a portion of the record is not confidential below, and you feel that it should be, then you would have to file a motion to seal the case. And the rules used to use the word seal. It's not actually a technical seal. You're not putting it in an envelope and sealing it. But that's how you make something confidential that is not already. It's also a good tip to use initials and descriptive terms like the father or the child. Briefs in family court cases are not made public generally in our court, but just in case you fall into a case where they are, it may be best to use that.
Question.
Yes?
What do the judges, the justices, prefer? Do they prefer initials? Do they prefer mother, father? Because there's a million different ways to do that.
Sure.
And I've done it a million different ways. But which does the court prefer?
So for children, well, first of all, the court prefers clarity. So if it's clear there's only one child in the case,
right,
you can say the child.
But if they're like Kardashians and everybody has a cake.
If there are multiple, then we use an initial for the first name and the last name of the child, and initials are preferred. If it's necessary for clarity. However, interestingly enough, with parents, it's usually the first. You spell out the first full name and then just the last name is an initial.
Okay.
But it just depends on the circumstances. A lot of these issues do. But if there's only one child in the case, you can say the child. If there's usually only one mother, you can say the mother. But it just depends on the case. Another thing that people sometimes miss in notices of appeal is there will be multiple cases in the family court, like the circuit court level, and if so, that should be indicated that there are related cases. It usually comes up when there would be, this is obviously just geared towards family court cases and not abuse and neglect. For example, if there are 3 separate children in abuse and neglect proceedings, and they're all separated and they have different final orders, and there are 3 notices of appeal filed. For judicial economy and economy of your work and your time and the other parties, it may be necessary to consolidate those cases. So knowing if there are related cases can be beneficial. So transcripts. Generally in family court proceedings, transcripts are not going to be produced at the direction or paid for by the state. Usually it's a DVD of the family court proceeding, and there may be some circuit court proceedings that are necessary, but generally speaking, transcripts of family court proceedings are not produced in family court meetings.
Excuse me, so,
Yes.
so you submit the CD, is that what you do?
You can, yep, the DVD. That's right.
I'm sorry, I didn't hear the question.
Oh, I'm sorry. The gentleman asked, so you would then submit the DVD in the record, and the answer is yes. Yes, you can. As long as it's produced to other parties and made part of the appendix. Yes.
Regarding the transcript, you can pay to have the DVD transcribed and submitted in that form too, correct?
It's generally not. The state will not usually pay for that. The Supreme Court will generally not grant a transcript request form to have a family court proceeding transcribed.
Then I'm talking about the actual part.
Yes, oh yes, it's private pay, if you want to do it on your own. Now, regarding that litem, it depends on what your role is. I'm not sure that would be an expense, but it could be. I don't know. But yes, a private party would absolutely have to transcribe. They have a court order. They can pay a court order to transcribe whatever they want. Yes.
I have a question.
Sure.
If you were going to cite to testimony that was given in the family court, then would we just reference to where it is on the CD so you'd be able to locate it as far as time, or do we have to transcribe that?
She said if you're going to reference the testimony in a family court proceeding, do you try to reference where it is on the DVD in the family court proceeding?
Or do we have to transcribe? I guess that's my
The
question,
rules-
if I'm specifically using testimony from the hearing.
As long as it's in the record, you can refer to it. It's in the record before our court. As to how you cite it, the rules don't specify how to cite the DVD.
Yeah.
So that's really best judgment. I can't give you a definitive answer about whether or not the cite would be proper. Generally speaking, if the court can find your reference, it's sufficient. It does come up. We get DVDs in most family cases on it. So.
Well, and if you're reviewing that DVD, and you know as well as I do, there's going to be a time in which that person's testifying, and that's what you're referring to. And if you can put the time in that during this, individual's testimony, I think that would be the best way to do it, because you don't want to waste the time of the justices or their clerks trying to go through an entire DVD. And for those really complicated cases where you have multiple hearings, you need to give them the date, of which DVD and the time in there. And I would say that that's best practice.
Be as helpful as you can would be my suggestion. I will say that they probably will look at the entire DVD anyway, but be as helpful as you can in your site. And like I said before, the notice of appeal can be found on our website. It's a document that's pre-prepared. It has some attachments that are necessary. They are on the website. So there are certain duties that are laid at the foot of the GAL when you get a notice of appeal. So it's throughout your role in the case. It's very important that when you get a notice of appeal, if you notice any inaccuracies in it, to inform the court. That would either be a letter by motion or just in some writing before the court. The courts have to function on the information they get, and one thing we tend to do, we get notices of appeal that list parties and non-interested individuals who may be included, and that's the sole information we get to evaluate the scheduling order and who to send material to. So if you are aware of an inaccuracy, let the court know. Otherwise, the court will not have the correct information. and update the court on the current status of the child, particularly if this information isn't elsewhere in the briefing before the court. That's really more for when you submit your brief. You don't have to do that separately. All right, so once a notice of appeal is filed, if it's proper, the court then issues a schedule order. And some of this is probably basic information that you need to know, but I thought I'd just walk through it anyway, just in case, and try to gear it towards guardians of litem. So if it's redundant for some of you, I'm sorry. So scheduling order will be sent to the individuals that are listed on the notice of appeal. So again, if we don't have the correct information, it's going to be difficult to send an order out. But we send it to the parties that are listed on the notice of appeal. The deadlines in the scheduling order are mandatory. So if it says the respondent's brief is due January 30th, it's due in our office on January 30th. Not mailed on that date, but in our office. One thing too about scheduling orders. Oh, I'm sorry.
I'm just wondering if there's, say, it's pro se parties, which a lot of times we make steps toward the guardian. And when the pro se people files and doesn't mention there's a guardian involved, once the court find out, how does the guardian find out that there was an appeal back?
Did you all hear what she said? She goes, if you have a pro se parties and one of them files this notice to appeal, gets everything right, and the scheduling order is sent out, sometimes they don't mention that there's a guardian, and so how does the guardian know what's happening?
It happens in attorney cases too. It's occasionally a problem. What we can do, and what we have done in the past, is to process a notice of appeal. There will be a final order attached. We can look at the final order and see if there was indeed a guardian ad litem. We will do that. But that said, if the person's not listed on the notice of appeal, sometimes that gets missed. And we hope not to have such a gap, but there's sometimes you don't know what you don't know. There's not much you can do. So we do take the extra step, usually of looking at the final order, seeing who the parties are, if they have attorneys, if there's a guardian ad litem. So there is that safety measure, but if they're not listed on the notice of appeal, it's different. I wish I had a better answer for you, but that's about it. So one thing I do want to mention about scheduling orders, they just list the parties in categories of petitioner and respondent, usually. So it will not say the guardian ad litem's brief is due on such and such a date. If you are not the petitioner, you are a respondent. So if it says respondent's brief due on such and such a date, the guardian ad litem is a respondent. Yes?
Can you cite the rule or statute that states that the guardian ad litem is a respondent party?
That's the practice in our court, that parties are designated as petitioner or respondent, just in the phraseology of the scheduling. Now they are, in your role, you are a guardian ad litem, and I don't mean to diminish that. Simply in the language of our scheduling orders, we don't spell out, even in civil cases, we wouldn't say, defendant XYZ court has a deadline of January 30th. We would just say respondent.
But the guardian ad litem is considered by the Supreme Court a party respondent, even though it's an appeal of an order by the family court.
Family court or circuit court order. Yes.
Right.
If a petitioner appeals and a guardian ad litem is a party below, any other party, so if the other parties who are active in the case when the appeal gets to us, when the petitioner files a notice of appeal, the other parties are considered respondents by our court. But in terms of that being in the statute or a rule, I'd have to look at our rules, but I believe that's the practice of our schedule orders. I'm not sure it's spelled out in your order. Yes?
Is the guardian ad litem still considered a respondent party if we've been ordered relieved from the case? A lot of times in family court, the judge relieves the guardian ad litem at either the final hearing or an earlier hearing. Are we still respondents that file briefs if we've been ordered relieved?
You may, when a notice of appeal comes into our office, you may receive that notice of appeal or the scheduling order in the mail, because you're either listed on the notice of appeal by the petitioner or you're in the final order and you attach that. If that's true, and you do not believe you are any longer part of the proceeding, then inform the court. So if you will get, occasionally you may get sent material when you don't believe you actually have any function in this case, in the case pending, and you just simply need to let the court know. Yes?
I'll give you a tip. If you get relieved as a guardian and an appeal comes out, go back to your family judge and get reappointed, so then you can get paid for your work on the appeal.
Just so you guys know, number 17 under your guidelines for guardian ad litem in family court, it says that a guardian ad litem shall be present at all court hearings and respond to all motions and appeals which affect the recommendation of the GAL or interest of the child during the pendency of the case. And so, in your guardian ad litem guidelines, you're responsible for responding to the appeals in a case in which you're making recommendations to the court. And this doesn't say except if you've been relieved of any further duties. So it would appear under those guidelines you are absolutely responsible to respond.
There also is in abuse, neglect, and other contexts, I'm not entirely sure about family court, but there are, generally you're appointed as a guardian ad litem until permanency is achieved. A child, a family court, I'd have to look at that distinction. But I would say inform the court if you believe you're no longer functioning in that role, and if they want to direct otherwise, they'll issue any decisions by order, so they will let you know. So once a notice of appeal is filed and a scheduling order is issued, the next step is perfecting the appeal. So the appeal is perfected with filing of a proper petitioner's brief and an appendix. The petitioner's brief is a document that's limited to 40 pages unless leave is granted to exceed that. You have to file an original in 10 copies with our office and 1 copy to each party to the appeal. And the appendix doesn't have a page limit, but you have to file an original in 1 copy to our office and 1 copy to each party. The petitioner's brief must contain 10 separate sections. A cover page, a table of contents, if the brief exceeds a certain page limit, a table of authorities, assignments bearer, a statement of the case, which is generally where a guardian ad litem would include information about the child. You can include it in a separate section, and actually abuse and neglect appeals, you have to include it in a separate section. But generally, that statement of the current status of the child would be in the statement of the case. The summary of the argument, a statement regarding oral argument, and decision. We often get petitioners' briefs that in this section they mention whether they think the case should be orally argued, but they don't mention what type of decision or opinion should be issued. So if you feel it's proper for a memorandum of decision, you can say that. In argument section, and actually one thing about the statement of the case in the argument section, remember to cite. We get briefs occasionally that we have to return or enter an order because they don't cite to either the appendix record or any law. And so please cite in your briefs. A conclusion and a certificate of service. So you have to serve the other parties. And the appendix record. So the appendix record, this is another area where sometimes we have to return filings. An appendix has to include documents that were part of the lower court proceeding, unless there's leave to do otherwise. So generally speaking, if some record is not part of the record below, we should not include it in the appendix. If someone has, you can also move to strike. If you're not the petitioner, you're another party. Parties are encouraged to confer and agree on the contents of the appendix. And if they don't, then there's a process and rules to exchange information to determine what's in there. The appendix generally consists of orders, pleadings, transcripts of the DVDs, a GAL report, for example, and lots of other documents. The appendix itself must contain a cover page, a certification page indicating that it is that they are true and accurate copies of what was in the record below, and that you've conferred in good faith with the other parties. A table of contents and its own certificate of service. And the appendix must be paginated. It's another area where people often they'll include material in the appendix, submit it, but it won't be paginated, and so it's very difficult to cite to or find anything in. If you feel that something should be in the appendix record that's not, then you can file, we'll get to motions in a moment, you can file a supplemental appendix. And for example, if a GAL, if you're, as an example, if you want to cite and refer to in your brief a report filed below, but the report's not in the appendix record, to cite to that in your brief and to have the court consider it, you have to file a motion to supplement with the supplemental appendix attached. So once the brief is perfected, then a response will be due. Now, like I said, this is probably going to apply to you more. Generally, you are an exempt item or respondents. So the response brief. The respondent has a choice of whether to file a full respondent's brief or a summary response. The main issue with filing a summary response that we'll get to is that you potentially waive your right to appear at oral argument. And the court can still order that you appear, but it is in the rules that if you file a summary response, you waive the right to oral argument. Respondent's brief. And it has a page limit of 40 pages. You file an original and 10 copies in our office, and 1 copy in each party. A respondent's brief generally follows the same format and guidelines as a petitioner's brief, except that the statement of the case is only necessary to correct inaccuracies or omissions in the petitioner's brief, and you do not have to restate the assignments of error. It happens a lot in respondent's briefs where they have an assignments of error section and they rewrite the assignments of error that were originally produced. You don't need to do that. One note, the respondent's brief, actually the respondent in responding, either respondent's brief or summary response, if you do not specifically respond to each assignment of error raised by the petitioner, the court will assume that the respondent agrees with the petitioner. So it's important to respond to each issue. So that's a respondent's brief. The summary response is different in that it's more concise. It does not have to comply with the requirements set forth in a brief or a longer respondent's brief. Its page limit is less, and again, it does have the possibility of waiving your presence in oral arguments. So once a response is filed, then the last action by the parties under the motions, oral argument, is a reply brief. The petitioner gets another chance to come back. The reply brief has a page limit of 20 pages. It's an original and 10 copies, and 1 copy served on each party. A couple notes about reply briefs, and this comes up quite frequently. Don't just reiterate the arguments you've already made. Generally, less can be more, less often is more in a reply brief. You have a very low page limit for a reason. They want to narrow the arguments to isolate the issues that were not raised in the petitioner's brief and that you just want to respond to from the respondent. So if you're a petitioner and you're filing a reply brief, generally just keep your brief to the rebuttal points raised in the respondent's brief that were not covered already. Once the briefing is complete, then the case will be mature for consideration. And there are different ways that a case can be considered and disposed. The court can decide the case on the merits without oral argument. It can decide the case on the merits with oral argument. And if that happens, then you'll receive a notice of oral argument with the date and time. Or they can issue an order disposing of the case in certain circumstances, if that's pertinent. And you'll be notified in writing of any decision. So the types of decisions, they're not by order. As you probably know, there are memorandum decisions and signed opinions. I won't go into the case law really about the difference, but generally, a memorandum decision, it's a decision that's not signed individually by a justice and it's not published. They can be cited as legal authority. They are legal authority. But when a conflict exists between a published decision and a memorandum decision, obviously the published decision controls. And a memorandum decision will often be a concise statement of the factual and legal reasoning of the court. I say that they are single-spaced, and oftentimes memorandum decisions, if you were to make them double-spaced, would be as long as an opinion. But they generally stick pretty tightly to the issues, factual and legal. And a memorandum decision is appropriate. So when if you have a statement regarding oral argument decision, and you're not sure about which decision is proper, Rule 21 says that a memorandum decision generally includes no substantial question of law. They can affirm when the court does not agree with does not disagree with the decision of the lower tribunal. And the court finds no prejudicial error and no other justification exists to issue a signed opinion. So once the case has been fully decided and submitted, fully considered and submitted, the final step in any case, once the decision is entered, is the mandate. So the case does not actually end in our court until the mandate issues. The mandate generally terminates the Supreme Court's jurisdiction over a matter, although the court does have the opportunity by order to allow a petition for rehearing to be filed after that mandate issues, but that usually does not happen. So that's generally the proceedings. I know it's, I hope you brought your coffee. I know it's very procedural, very bland. It is important stuff because we see so many issues with the pleadings in these cases. That's generally the life of the case. Now here are some other matters that may be relevant to you. For every case that's issued, for every 10 cases that are issued, you might get one petition for rehearing. But that is an option for you if you disagree with a decision of the court. You can file a petition for rehearing within the time frame allowed by the rules or by order if it's different. Because the time frame can be shortened or enlarged by order for filing a petition for rehearing. A petition for rehearing, generally the court allows a response period. If you file a petition for rehearing because you disagree with the decision, the other parties will generally get an opportunity to respond. Upon consideration, the court may refuse the petition for rehearing or grant it. If they grant it, then they have a variety of options. They could ask for rebriefing on an issue or the entire case. They could have subsequent argument again, or if they hadn't had it before, just have an argument. You could start from ground zero or start from a different part in the process. So it's very important to look at the order granting a petition for rehearing to see what comes next. Some common issues with motions that we see. We get quite a few motions for extensions of time or motions to file out of time. Those are different. So a motion to extend a deadline is filed if the deadline's coming up and you're not going to file your pleading on time. A motion to file out of time is the mechanism if you're filing your pleading but it's late. So a motion for extension of time when filed out of time must demonstrate good cause for the extension or the untimeliness. The motion should be specific, indicate the time that's actually needed. We get a lot that just say, I would like an extension. It's much better to say, I'd like an extension of 15 days or 30 days and give a justification for that. You're more likely to get your relief if you're specific. In cases involving children, which there would, the motion should also explain, or a response to the motion should explain how the delay would affect the child. If you're coming up against a deadline and you want to file by fax, our office does allow for that, but you have to file a motion to file by facsimile. So the court has to grant leave to do that. You then also have to follow up by mailing an original and a number of copies to our office. The main reason to file the motion by fax is simply to meet a deadline. Yes?
Is the fax requirement, does that apply to all pleadings filed or just the briefs?
She says, does the fax requirement apply to all pleadings filed or just the brief?
It applies to all pleadings. Any document can be filed by fax within a page limit. The court's probably not likely to grant leave to file a 3,000-page appendix by fax. But that said, a motion or a brief, if you fax in a motion to file by fax along with your brief, then that can be considered. Also, you would only have to fax one copy, not all the copies necessary.
Should you file the motion to file by fax with the motion if you're doing a separate motion, or?
So she asked, should you file the motion to file by fax with the pleading that you're filing? And the answer is yes. Yes.
Does the court lean towards moving towards, I guess, electronic filing? Because, like, for some of us, like in the Eastern Panhandle, we're at a disadvantage where if you're down here, you might be able to extend that deadline a couple extra days, but we wouldn't have that advantage where we are. Is the court leaning that way towards electronic filing?
Well, Courts Plus, which is the electronic filing system in the state, has grown substantially in the last few years. I don't have a time frame for when that's going to expand further in the counties, or if it's going to expand to out of court. I would assume if we could peer into the 22nd century, I'm sure we would have that ability, but I don't know. I don't know when. So I can't be specific. Yes?
In your experience, if you file a brief, say your petitioner's brief, and we file the motion to file back facsimile, and you're filing on the last day, and you're up in northern West Virginia, does the court ever not grant that? Because I don't want to take a chance by filing a motion and the court say no.
Well, in the scheduling order, if there's already been an extension, the court does give you a time frame, so 45 days or so to file a response brief. So there is that time frame. If you're trying to file on the last day of that time frame, then you are going to take a chance. I cannot give you a guarantee that the court's going to grant every motion to file by fax. I would say the vast majority are granted, but that does not mean that it will be granted in every instance. So I would say be careful, just like in any other pleading, be careful about walking too close to the line on deadline.
Yeah, I just didn't know whether it was a formality or whether it could actually be denied, so.
It depends on the circumstances. One thing I was thinking about that I didn't include in this PowerPoint that would come up, I think, in cases you're going to be involved with in this capacity as a family court guardian ad litem, motions to stay. We get motions to stay occasionally, and that is something that may be necessary in your case. generally proceedings that you may consider adverse to a child or that you appeal or that are appealed. They're not going to be, in my experience, it's going to be stayed in the lower court, not stayed automatically in every case. So you can also file a motion to stay. Rule 29 governs motions in our court, and they don't, Rule 29 is not specific about what types of motions you can file. So there is some room for creativity in motions practice. Most motions that are filed have a period for the other parties to respond. So if there's a motion to stay, another party may respond and say, we do not need to stay in this case. Some motions are granted without a response. If there's a motion to file at a time, the court does not have to wait the 2 to 10 days for a response. So not every motion is given that response period. Some motions are acted on more quickly. But generally speaking, motions do have responses. And please respond. The court wants to know, especially what a guardian ad litem will think of a motion for stay filed by a petition. So that responses are important. Complying with the general rule on form or filing. Rule 38 of our rules spells out all the nitty-gritty details of paper size, format, spacing, the cover page, and caption of the case. By rule, the caption of the case it doesn't matter what the lower court's order says or what is in the notice of appeal. What is issued on the scheduling order, top of the scheduling order, is the caption of the case in our court. So Rule 38 spells out some of the details of, I think I talked about facsimile filing. Filings immediately prior to argument. There's a rule that says that you cannot file anything with the court within 48 hours of the argument. That can be relaxed by the court if necessary, if they want status update on the child before argument, it's not in, that type of thing. But generally, before an oral argument, be very careful about how soon before the argument you're trying to file something. And please use the docket number that's assigned in the scheduling order. If a case is docketed, it gets a separate number in our office than it had in the proceedings below. So please use that number. We do not have any system or database for the lower court numbers. So we simply go off the court number that's generated in our courts. And Rule 38 does have a chart that's helpful. It has the type of document, the page limit, the number of copies that are required, and in different types of proceedings. Oral arguments. Material up here. So, as I'm sure you know, there are two different types of oral arguments. Rule 19 and Rule 20. Rule 20 is generally reserved for issues of new law or constitutional enforcement, that type of thing. Just some tips. Know your facts, especially as a guardian ad litem, the status of the children. Guardians ad litem are almost always asked, as I already said, well, where's the child now? So please know your facts, your legal authorities, of course. Time's not unlimited, so it's always best to present your strongest points to make sure you get them across. I would suggest, although it's just my opinion, to be direct. If you disagree with the point, feel free to say so. If there's something that the facts and law are just clear, I would suggest conceding it instead of fighting a point that's absolutely clear. I think it can affect your argument. In Rule 20 cases, the court often will come up with a new syllabus point defining new law on an issue. So it's always good practice in a Rule 20 case to have an idea for the court of what that new syllabus point should look like. And that's something they occasionally ask. And the last thing I mentioned, I probably shouldn't have put this last. So please comply with the rules of appellate procedure. If you have questions, feel free to call our office. We try to help as much as we can. We can't help with every issue. We can't answer every question. We try. The court can impose sanctions if guardians ad litem do not comply with the rules, they take the role of guardian ad litem very seriously because, as you know, the court's not going to go out into people's homes and find out what's going on with children and rely on guardians ad litem to be their eyes and ears. So, types of sanctions, it can affect future court appointments. It can, a case matters can be referred to DC, and other sanctions. So please follow the rules. And like I said, if you have any questions, please contact us. We try to be open. So with that, if there are any additional questions.
Thank you.
And